continuation pa rin tayo. This is day 3 of the confirmation of charges hearing ng FPRRD, second session. So dito po, tinatch on ni Atty. Kaufman yung PNP circular during the time ni FPRRD dun sa presidency po niya. And then before we start po, just a quick clarification lang po sa inyong lahat kasi yung mga old videos ko po dito sa ICC case ng FPRRD ay medyo nabubuhay po kasi nakapick up siya ng views lately. So just a reminder po to all of you na nanonood na always check the date of the upload po kung whether or not bago or lumang video ba yun kasi baka maguluhan po kayo. Hindi ko po kasi kaya na ma-replyan lahat ng mga nagtatanong dun sa old videos ko kasi mukhang nakukorelate nila na akala nila yun daw yung mga bagong videos. Okay, so anyway po, going back, this is day 3, second session. Ngayon, panoorin po natin kung ano yung defense ni Atty. Kaufman.
And the issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. This directive instructed investigative units on how to perform their responsibilities in a case of armed confrontation during the implementation of Operation Double Barrel. The document also included an exhortation to monitor human rights violations perpetrated by PNP operating units. The term neutralization itself is, of course, not defined anywhere in any of these documents as meaning to kill, a point the prosecution itself conceded at that moment in time when it was seeking the opening of an investigation. And I refer, Your Honours, to ICC 01 on 21, document number 7. So, the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defence, can show that the term neutralization can only mean the use of self-defence where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Beto, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, de la Rosa, testifying before the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, a police intervention in strict accord with the use of force continuum and or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect.
Okay.
It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this.
Okay, wait guys, comment muna tayo. Magandang ano yun, magandang defense ni Atty. Kaufman. Okay, so kaya ko po nasabing magandang defense yun ni Atty. Kaufman doon is because one of the legal theories po kasi or the legal position ng prosecution is the indirect co-perpetrator angle versus FPRRD, meaning via nga his political speeches, yung mga exaggerations niya doon ay that resulted to the police officer na ginawa yung mga pagpapaya ng certain class of individuals who according to the prosecution will fall under the definition of class of persons para pumasok sa crimes against humanity. So my point lang po, kaya ako nasabing contradicting yun siya kasi indirect perpetrator yung one of their main allegations nga po. However, ngayon, they are also alleging na in the police manual na linagay doon yung word na neutralize which means pagpapaya. So doon po ngayon, nag-contradict yung dalawang legal position nila. Is FPRRD really an indirect perpetrator ba or a direct perpetrator via the police manual? And then yung maganda dito na naging discussion is because nirebat ni Atty. Kaufman via the police manual itself na pinakita niya na may term na neutralization doon sa police manual and then may specific definition na pinrovide kung saan doon po sa binasa ni Atty. Kaufman wala namang term or word na papaya na ginamit talaga. Okay, and then ang masasabi ko lang din po dito na if i-insist ng prosecution yung word na neutralize means papaya talaga, if we will just follow basic reasoning, reasonableness, test of reasonableness, kung ako lang po sa tingin ko wala namang reasonable na isang politiko or isang public servant na maglalagay ng isang term sa police order para basically parang magkaroon siya ng mga criminal liability later on, di ba? Kasi parang maging admission yan eh. Kung ilalagay mo neutralize means papaya pala. So parang nilegitimize mo talaga yung pagpapaya. Which in this case, kung ako po tatanungin, mukhang hindi naman kasi may clear definition naman dun sa PNP manual na hindi nga daw pagpapaya yon. So yan lang po, kung ako po tatanungin, medyo na-contradict ng prosecution yung sarili nila kasi indirect perpetrator. Now dito naman direct perpetrator because may nilagay daw na term na neutralize, and then kinounter ni Atty. Kaufman na yung neutralize does not mean papaya, rather it means yung binanggit niya kanina na may kailangang steps na gawin para magawa talaga yung pag-arrest sa isang akusado. Okay, so yan po ang masabi ko as to that. Pero ang further lang din na ma-add ko pa to this is titingnan pa rin kasi talaga yan yung totality of evidence ng judges later on. Diba? Hindi lang naman itong specific issue na to. Yung titingnan nila to decide kung whether or not may substantial grounds ba para mag-proceed sa trial si FPRRD. Pero currently dito medyo nagulo-gulo lang. But I'm guessing meron naman siguro yung explanation din yung prosecution later on. So anyway po, tuloy tayo para mas mapakinggan pa natin yung mga explanation.
It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't because it's not on their list of evidence.
Okay.
Within
So
the
quick comment lang. Wala daw sa list of evidence ng prosecution yung police manual. So kung ako po tatanungin, sa tingin ko plus points yun sa defense kasi now it appears na yung prosecution are really trying to insist on a specific definition of the word neutralize. Pero kung titingnan sana yung official documents ng police force natin kasi yung police police policy, basically police circular, may kita yung proper definition talaga ng term na neutralize. Okay, so anyway po, tuloy tayo.
judicial sphere, when the terminology was examined before the Supreme Court of the Philippines in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill.
Okay.
The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP Manual on Anti-Illegal Drugs Operations and Investigation. In other words, the term formed part of the existing police vocabulary. The court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional, especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses, no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill.
So that's an actual witness sa ICC, itong sinasite ni Atty. Kaufman po. Kaya may mga specific numbers.
Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
Maître, je suis désolée de vous en...
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of course,
Thank you very much.
an understanding with the learned chambers legal officers that we would be able to provide
Okay, comment muna tayo guys kasi may binanggit si Attorney Kaufman about Supreme Court natin yung kanina eh.
Buti.
So just a quick break lang po. Gusto ko lang po magpasalamat sa inyong lahat, my fellow taong bayan, mga ka-Seymour ko. Because we have recently crossed the 380,000 subscriber mark po. So thank you very much po sa lahat na nag-subscribe. And of course, thank you in advance po sa mga magsasubscribe pa lang. And tandaan po ninyo, pag sa YouTube po kayo mag-subscribe, 100% free po yan. So hopefully po, you can consider subscribing. And of course, i-like din po mismo yung video na to. Okay, so ngayon po, tuloy tayo sa discussion. So ito pong explain ko ngayon more on ano ko po to, expert point of view lang kung bakit hindi dinedeclare ng Supreme Court as unconstitutional yung certain policies ng FPRD as stated dito ni Attorney Kaufman. And sa tingin ko po kaya yun ganyan yung position is because if we will declare unconstitutional certain policies because may mga na papayang individuals or may mga nabawian ng buhay po na individuals accidentally, it would lead to a very complicated scenario kasi alam naman po natin if it is a government policy that involves either the police or the military, meron po talagang tinatawag dyan na collateral damage which is yung namamatay because of the implementation of the policy. So, yan yung dilemma. If we will declare as unconstitutional yung certain policies because may mga, yun nga, nabawian ng buhay in legitimate government operations, magiging very complicated po ngayon to govern or para ipatakbo yung isang bansa in relation to government and military policy. So yan yung tingin ko kaya hindi na-declare as unconstitutional yung war on drugs ni FPRRD according to Attorney Kaufman. Hindi naman po sa sinasabi ko na walang value yung mga nabawian ng buhay. I would just like to emphasize and make that very clear kasi baka i-twist po ng ilang individuals yung mga words or statements kung ganito kasi alam naman natin this is a very highly sensitive topic, diba? So anyway po, going back, if we will just declare as unconstitutional or illegal certain policies because yun nga po, may mga collateral damage, then it will be very complicated nga like what I've already explained. So ang kailangan talaga tingnan dito is whether or not meron bang violation sa batas per operation. So, ang alam ko naman po, may certain cases dito sa atin na yung mga abusado, napakitang abusado talagang police officers ay nakulong. So, yung next question talaga dito na kailangan ma-establish ng prosecution is whether or not yung mga ganong actions ba ng mga abusado ay pwede maging indirect co-perpetrator si FPRRD. So, anyway po, tuloy pa tayo sa discussion.
references after the hearing, but of course the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue.
Trash talk sa Attorney Kaufman.
Indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald De La Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, if you resist. That's PHL OTP 0000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 0009-00340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone, and God forbid we're not alleging that Aguirre did anything wrong, especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4, and I read out the relevant passage which is highlighted. Once again, they are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal.
Okay, wait. Comment tayo guys. Comment tayo. Maganda itong mga na-discuss na ni Atty. Kaufman eh. So una i-discuss ko muna yung sinabi ko nag-trash talk sa Atty. Kaufman. Sinabi niya dito basically na since yung isa sa foundation ng legal theory ng prosecution based on sa other charges is the police circular na may term na neutralize, and since na-explain naman daw niya na based sa batas ng Philippines dun sa PNP circular na hindi neutralized, that neutralized does not mean papaya, rather to arrest or perform another action to be able to fully apprehend an accused or a suspect, ay lamang na daw sila. Yun yung point doon ni Atty. Kaufman. And because of that, since yun din yung basehan sa other charges, pwede na daw sana sila mag-stop. Pero magko-continue pa rin siya. So that's in a way parang trash talk po yan kasi directly na niyang inaano sinasabing yung foundation or fundamentals ng legal theory ng kabila is malabo. But of course, that is not for Atty. Kaufman to decide kasi yung judges pa rin po ng ICC yung magsasabi kung whether or not may substantial grounds ba. And then yung isa pa na sinabi ni Atty. Kaufman yung sa last part, kaya daw ngayon mukhang may selective na presentation yung prosecution kasi baka daw yung ginagawa ng prosecution ay nagsisearch lang ng mga keywords or key highlights na pumapasok lang dun sa legal theory nila. Tapos of course, yun lang ngayon yung papakita ng prosecution at yung pupuktukin ng prosecution para mas mapalakas yung legal position nila. That is according to Atty. Kaufman. Of course, at the end of the day, that's up to the judges nga po to decide. Pero dito, pinapakita lang ni Atty. Kaufman na dinidiscredit niya yung style ng prosecution ngayon na medyo hindi daw pinapakita yung full picture kasi in one speech there is certain terms na pabor sa prosecution, but if you read daw po the full context or the full script, makita mo na may clarificatory statements sa FPRRD. Okay, and ang masasabi ko lang naman po for the side of the prosecution, of course, kung ikaw you are trying to prosecute, gusto mo po mapakonvict talaga or dito gusto mo mag-continue yung trial to the trial proper talaga, yung case to the trial proper talaga, of course, you will find everything that is only favorable and beneficial to you. That is really the function po talaga of a lawyer. You have to strengthen your legal position. So, yung ano lang dito, at least na defend ni Atty. Kaufman ng maayos kasi napapakita niya yung full picture. Okay, and then ang masasabi ko lang din po dito, if this one, my personal observation ko na lang po to since isa po sa pinapagbasihan talaga ng prosecution ay yung mga political speeches nga ni FPRRD. Tapos kung makita nyo sa political speeches itself ni FPRRD, merong ganito, tapos mamaya liko na naman sa baba, tapos mamaya liliko na naman yung gusto niyang iparating or ipaintindi po sa taong bayan. So ang point ko lang po, kung masyadong madaming paliko-liko or mga contradictory statements ang isang tao, therefore yung statement na ganon will be highly questionable as to its evidentiary value, 'di ba? Kasi how will the judges rely on a statement kung masyado ng madaming paliko-liko or sometimes even contradictory statements, 'di ba? Doon pa lang matetest na yung credibility. But of course, doon ngayon papasok yung inexplain ko nga sa last video na baka lang naman i-consider ng judges na since si FPRRD is a former prosecutor, matagal siyang mayor, baka alam niya yung batas, so therefore hinahanapan talaga niya ng indirect nga na pag-order. So yan yung mga legal principles sa tingin kong possible or pwede pa i-consider ng judges dito. Aside po from those na didiscuss ng defense and prosecution. So anyway po, tuloy ulit tayo.
Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief, none of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality.
Wait lang, yung uso sa atin guys, dehumidifier Di ba? Pero anyway, tuloy po tayo.
I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations, Double Barrel and Pokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte, but this does not indicate a meeting of minds, as I will elaborate shortly. The eighth.
Okay, so comment muna tayo guys kasi maganda yung nabanggit dito ni Atty. Kaufman. So according to Atty. Kaufman, yung mga witnesses daw na sinabmit ng prosecution, wala daw nagli-link up doon na may na may sa atin po yung term dyan is conspiracy, na meron silang similar criminal intent to perform a conspiracy of criminal actions. So in other words, kada commit ng crime allegedly ng witness ng prosecution ay ibang separate crime yon according to Atty. Kaufman. So sa ganyang defense po kasi ni Atty. Kaufman, hindi ngayon ma-establish or mahirapan ngayon ma-establish yung fact na merong planned criminal action si FPRRD para targetin talaga yung specific class of individuals. Kasi yun nga po, according to Atty. Kaufman, even the witnesses of the prosecution, pagbabasahin daw po yung transcript ng interview nila, it would appear na iba-iba yung criminal intent and purpose ng per crime na kinumit nila allegedly. Okay, and then yung isa pa po na binanggit dito ni Atty. Kaufman yung sa mga paggamit ng mga colorful terms, tawagin na lang po natin colorful terms, si FPRRD in relation to mga drug, to individuals who are involved in the drug industry, may it be as a user, pusher, or drug lord. So according to Atty. Kaufman, yung paggamit daw po ni FPRRD ng mga colorful terms na yun does not mean na he is referring to them in a manner that would fall under the definition of crimes against humanity, na may specific criminal plan nga daw po na pinang-target towards that class of individuals. So yun yung position dito na gusto i-establish ni Atty. Kaufman. Okay, so anyway po, tuloy tayo.
Factor, purportedly evincing a plan of agreed criminality, is set out.
Uy, naputol bigla. Siguro may mga redacted. Okay?
Publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published in two government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations have been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station was sent for retraining.
Okay. So, stop muna tayo guys kasi medyo mahaba-haba na to. Naka 35 minutes, 37 minutes na po tayo of video ni Atty. Kaufman. And so, magbigay na lang po ako ng final explanation as to dun sa last na statements ni Atty. Kaufman. Yung main defense ni Atty. Kaufman dito is still the same na nitpick lang or pinipili lang ng prosecution daw yung mga keywords, key highlights from the government report without showing the full picture. Like dito, pinakita daw nila na may mga deaths na ganito from the drug operations. But like what I explained nga previously, diba, kung mapakita kasi na legitimate government policy talaga yun, kasi declare din or i-consider din ng ICC na legitimate yun talaga siya, mahihirapan yung prosecution talaga doon because like what I have repeatedly mentioned already, pag legitimate government operations, military police, talagang may collateral damage nga po na tinatawag. Okay, so anyway, going back, yung point dito ni Atty. Kaufman is pinakita lang yung papabor sa prosecution pero hindi pinakita yung hinighlight niya doon na may police officer din na ng abuso na nakulong ng life imprisonment, and then yung station na yun, yung sa Caloocan daw, tinanggal din lahat ng police for retraining. So yung maganda lang dito, at least napapakita ni Atty. Kaufman yung full picture talaga ng mga evidence na present ng prosecution, which will now allow the judges of the ICC to decide based on the full presentation po talaga as to the facts or circumstances of the case. But of course, syempre si Atty. Kaufman being the defense lawyer, yung position talaga niya ay sirain or basagin yung legal theory ng prosecution. So talagang depende po yan sa ICC judges kung paano nila titimbangin yung mga arguments ng both parties and then the evidence presented by both parties in relation to the factual circumstances. Okay, so yan lang po ang masasabi ko muna. Hanggang dyan lang po muna tayo kasi masyado nang mahaba. Apologies po kung bitin, pero of course limited lang din yung time natin sa pag-edit and pag-record. So anyway po, hopefully you enjoy this video at klaro po yung mga na-discuss ko. If you like more legal videos on current events, subscribe lang po kayo sa channel ko, and until next time, see you all po. Bye-bye! Okay, so good day my fellow taong bayan, at ngayon po i-discuss natin yung day 3 ng confirmation of charges hearing ni former President Rodrigo Duterte sa International Criminal Court. So as you can see here po, this is the International Criminal Court website, INTL Criminal Court, 191,000 subscribers po yung basehan ng ating video for today para ma-verify nyo talaga na legitimate itong pinapanood natin at hindi spliced up or edited. Okay, and i-clarify ko lang din po na kaya ko skinip yung day 2 is because yung day 2 po kasi is the side of the prosecution, yung pag-present ng evidence. So to have a better understanding po of the full picture, it would be best kung i-discuss natin yung defense na evidence, kasi of course yung defense, binabangga nila yon against the evidence ng prosecution. So mas makikita natin yung clear picture, yung both sides talaga, side of the prosecution and side of the defense, because again, the defense will directly be attacking the allegations of the prosecution. Okay, so hopefully klaro po yan.
President, Your Honors, it is the same lineup as previous days. I will go no further than that in French. The presiding judge, thank you very much. We can now move on to the defense and their submissions on the merits.
Okay, comment lang muna tayo guys. Baka nagtaka kayo bakit boses lalaki yung si presiding judge, si Judge Motok. At ano lang yan, yung translator po, lalaki yung translator. Pero hindi po ganun yung actual boses ni Judge Motok. Baka lang magulat po kayo eh. So anyway, tuloy po tayo.
You may address the court.
Now, before I start, I would like to make one general comment, and it's a comment which every defense counsel who appears before this court is obliged to make. So, if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defense's submissions, I hope that they will at least communicate the following faithfully. The defense does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be leveled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defense's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defense's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defense's role is simply to persuade your honors that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing your honors to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day.
Okay, comment muna tayo guys dun sa pinaka-opening remarks ni Atty. Kaufman. So una po, makikita ninyo sinabi ni Attorney Kaufman na hindi po nila dinidiscredit yung mga nawalan ng buhay, and basically ang point ni Attorney Kaufman doon ay ginagawa lang nila yung trabaho nila na ina-explain yung side nila sa defense, but they are not stating na yung mga nawalan ng buhay na ganyan ay walang value or walang sense yung mga yon. Kasi kailangan lang po yan sabihin ni Attorney Kaufman because pag yung mga victims po kasi ng isang case, isang criminal case, of course sila po, emotional talaga yun sila because sila yung affected parties. Sila yung either nawalan ng family member, nawalan ng properties, nawalan ng assets. Pero sa amin po kasi as lawyers, ang tinitingnan lang talaga namin is the facts of the case and the evidence presented. So pag ganun, ang dating sa amin parang wala kaming pakialam sa emotional side. Hindi naman po sa wala kaming pakialam, pero we really have to remain professional kasi to be able to fully explain talaga the side and the legal position po. Kung halu-haluin po kasi yung emotions, baka makloud din yung judgment namin as lawyers, diba? Baka magkaroon kami ng biases. So, yan po ang magandang opening statement dito ng Attorney Kaufman. At least kinlarify niya yun na hindi naman kami manhid sa mga nawalan nga ng buhay na ganyan. But as lawyers, we really have to remain professional to be able nga po to fully represent our client in court. Okay? And then yung pangalawa po na in-emphasize naman ni Attorney Kaufman dito ay yung mainstream media daw dito sa Pilipinas, according to Attorney Kaufman po yun ay mahilig daw mag-splice up ng mga content para in simple terms ma-sensationalize yung mga bagay-bagay, which was eventually used nung prosecution. Tapos sinabi niya doon, out of the 20 speeches, 10 daw doon ay in the very same speech na contradict yung actual na pinakita lang or sensationalized portion of that speech. So yan lang. I'm sure kayo po, may fellow taong bayan, may masasabi kayo dyan kung ano tingin niyo sa media, kung whether or not namimili nga lang ba ng certain portions para ma-sensationalize. Okay, so may kanya-kanya po tayong observations dyan. Okay, so anyway po, tuloy tayo.
Which I promised the other day to show you. This is a speech, the second speech that the Deputy Prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the Deputy Prosecutor read from this speech. So that the police is under the DILG. So I have to believe the story of the police, for simply, they are my subordinates, and I am ultimately responsible for their deeds. Now let's look at what the Deputy Prosecutor didn't state from the same speech. And the order is simply this. Go out, arrest them if you can. But if there is no peaceful method of doing it and you're presented with violent resistance, thereby placing your jeopardy in your life, you shoot. Well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL OTP 00001127 at page 5. And I quote, but if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility. Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, just do it right. We have our trainings that you can only kill if your life is in danger. And you are there performing the duty of a law enforcer. That's about it. Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find.
Okay, wait, comment lang tayo guys. So basically yung diniscuss na Attorney Kaufman is self-defense. So meron naman po tayong self-defense provision sa batas po natin, specifically Article 11 po yan, Revised Penal Code. So if there is danger to your life or to your person, tapos yung nagsimula po ng kaguluhan na yun ay hindi naman kayo kundi yung other party, you have the right po to repel the aggression that is being directed towards you. So yung tinitingnan na lang dyan is whether or not reasonable ba yung means employed and kung saan talaga nanggaling yung unlawful aggression, kung sino ba nagsimula talaga ng aggression, ikaw ba or yung na-injure or yung nabawian ng buhay. And when I say reasonable means, it means na yung ginamit mong pang self-defense is proportionate to the attack na kinaharap mo. So kung let's say bang-bang yung meron kalaban mo, then it is reasonable na bang-bang din yung pang-defense mo. Okay, so yan po ang basics ng self-defense. Anyway po, tuloy tayo.
And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech, which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this: "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat again for all and for everybody's consumption, do not kill if you are not in danger of losing your life." Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask Your Honours and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had a speech of 2 pages prepared, but to his regret it didn't come from the heart? And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy. Quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument, because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that does not help the case for the prosecution at all. Well, that's about it for the speeches. I'll now talk.
Okay, comment tayo guys. Maganda tong diniscuss dito ni Atty. Kaufman. So just a quick break lang po. Gusto ko lang po magpasalamat sa inyong lahat, my fellow taong bayan, mga kasimor ko, because we have recently crossed the 380,000 subscriber mark po. So thank you very much po sa lahat ng nag-subscribe, and of course thank you in advance po sa mga magsasubscribe pa lang. And tandaan po ninyo, pag sa YouTube po kayo mag-subscribe, 100% free po yan. So hopefully po you can consider subscribing, and of course i-like din po mismo yung video na to. Okay, so ngayon po tuloy tayo sa discussion. So based from my understanding ng explanation ni Atty. Kaufman nung nirelate niya po dun sa side ng prosecution, ay may appearance ngayon na mukhang tinitake out of context ng prosecution yung mga political speeches ni FPRRD para ma-pinpoint nila na may mga directive or orders sa FPRRD na magpapaya ng tao talaga. Okay, so yung papaya pala, that's the term for pag ginanon yung tao. Hindi ko lang masabi kasi baka ma-censor tong video ko kasi I had a old video when I mentioned the actual word na na-restrict. So to avoid that, ginamit ko na lang po is the term papaya kasi malapit naman po eh. Okay, so anyway, going back. So yun nga po, ang sinabi ni Atty. Kaufman, minsan daw may speeches FPRD na 2 pages lang, but he would go on personally discussing na lang ng mga bagay-bagay based on his actual personality and from the heart niya, kaya humahaba ng 1 hour yung 2-page speech. And I'm sure na familiar naman po kayo doon, my fellow taong bayan, sa mga ganong speeches ni FPRRD. So ang problema po, kung ako lang tatanungin ninyo, kung yun yung basihan nila na nagkaroon ng direct order sa FPRRD para magpapaya ay yung mga ganong speeches, ay doon po ngayon nga papasok yung sinasabi ko na pag political speech talaga, mahirap yun siya gawing basihan kasi generally political speech nga po is in a sense exaggerated, diba? Kasi it tends to, or its purpose is to gain support from supporters niya sa isang politiko or dun sa mga policies na gusto niya i-push. So kung yun yung basihan nila, yung mga ganong statement na political speeches, it is, kung ako po, ang assessment ko mukhang malabo po yun kasi political speeches are usually exaggerated po. Hindi lang naman si FPRRD, kahit sino pong politiko, pakinggan ninyo yung political speeches, madami po talagang sinasabi yan na maganda pakinggan na mga statements, di ba? From all sides of the political spectrum, may ganyan po talagang statements yung mga politiko, okay? And yung isa pa po din natin kailangan i-consider dito is, of course, the personality of the individual. Kung kilala siya na mahilig magbiro, mahilig mag-exaggerate talaga, then mahirap yun siya seryosohin. Kasi again, the mindset of an individual, yung criminal intent is very important in criminal cases eh. So yung kailangan na lang dito mapakita ng prosecution, kung ako po tatanungin ninyo, ay na baka since si FPRD is a lawyer, a prosecutor, so alam niya yung batas, baka tinitwist niya yung mga statements niya para magmukhang indirectly, dinadirect daw niya gawin yung mga certain actions. Parang ganun po. Yung problema lang po sa ganyang position, kung ako po tatanungin ninyo, ay madami na masyado tayong speculation. Di ba? We are going to speculate na because he is a lawyer, a prosecutor pa, a former prosecutor, eh baka he is now trying to twist the words or make it appear na joke lang, pero yun pala that is an indirect. Doon pa lang po sa side na yun, speculation na, and then next may speculation pa ulit na yun pala it's an indirect order na para magkaroon nga ng mga papaya na yun. So yun yung dilemma ngayon ng prosecution. Kung ako po tatanungin based on this defense ni Atty. Kaufman sa speeches na kailangan nila ma-overcome kasi yun nga po, madami ng mga speculations masyado, and we have to remember in criminal cases, again, reasonable doubt. So kung gano'n na lagi tayong teka lang, pag ganyan po, hindi yun reasonable doubt yung magiging mindset natin yan. Okay, so anyway po, tuloy tayo. So ito po, yung sa crimes against humanity naman na elements of the crime. Okay, so pakinggan po muna natin si Atty. Kaufman.
I'll now turn to crimes against humanity and the contextual elements. And here I would like to start off by addressing the requirement that the acts of murder alleged be committed as part of or in themselves constitute a widespread or systematic attack. The second requirement is that these acts of murder be directed against the civilian population. With respect to the unique ICC requirement of an organizational policy, I would suggest that this concept has been conflated with the common plan, and as such, I shall address the matter later in my submissions. So, to start by reference to the widespread or systematic nature of the attack, I would like to draw your Honour's attention to the fact that Count 1 contains 9 incidents of murder in one city, Davao, hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of Count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to produce the prosecution on the matter is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for
Okay, so comment muna tayo guys. So basically yung point to ni Atty. Kaufman is yung count 1 daw dun sa crimes sa Davao City, na crimes against humanity sa Davao City na FPRD. Kung ibibase lang po natin sa diniscuss ni Atty. Kaufman dito, ay mukhang hearsay yung basis ng prosecution na evidence na sinabmit nila, kasi yung pinagbasihan po nila is the Senator Leila de Lima, tapos yung next pa doon, yung mga bangkay daw na na-recover sa isang quarry sa Davao ay hindi pa nga daw po fully na-verify kung whether or not yun ba yung mga alleged victims nga ng crimes against humanity or World War II remains. So doon po medyo may hirapan kasi need yan of course ma-identify. If you are trying to establish na related yun sa crimes against humanity in relation to yung order nga na ipas lang o na ipapaya yung certain class of individuals, you have to be able to establish na yung bangkay na yun is talagang related doon. So yun yung need ma-clarify ko, ako po tatanungin ninyo. Otherwise, it could be argued na hindi sufficient kasi hearsay pa lang yung evidence. Okay, so anyway, tuloy po tayo.
For counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without of course proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient.
Okay, so quick comment lang guys. So yan po may sinite si Atty. Kaufman na jurisprudence ICC na kailangan nga ma-identify and that yung mga NGO articles or media reports are not sufficient to be able to establish kung whether or not yung mga ina-allege na victims ay part nga dun sa crimes against humanity. Based po dito sa diniscuss ni Atty. Kaufman na jurisprudence sa ICC.
Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered. But she neglected to contextualize these numbers by reference to other parts of the same report, which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages.
Okay, so comment lang muna tayo dito, guys. So dito si Atty. Kaufman is trying to show na since maliit lang yung percent ng namatay sa overall drug operations, anti-drug operations ng government ni PRRD, therefore wala na daw crimes against humanity. Okay? So ang masasabi ko lang po dito, hindi po yun fully correct na legal position kasi pag crimes against humanity, yung isang element doon is targeted towards a specific class. So kung mapakita po ng prosecution na may orders si FPRRD na tinarget niya which led to the death nitong 3%, although kahit minuscule lang, 3% lang, pag mapakita nga po ng prosecution na may order, therefore pwede pa rin po yun pumasok ng crimes against humanity. Pero hindi po siya automatic na ganun. Kailangan mapakita ng prosecution na meron talagang order na pinatarget ni FPRD yung specific class para ipapaya. Kasi yun po yung isang element ng crimes against humanity. So yung magbabanggaan po talaga dito sa presentation na to ni Atty. Kaufman, kung ako po tatanungin nyo is number one, whether or not, ito po side ng defense, whether or not legitimate government operation or government policy ba yung ginawa ni FPRD which led to the death of 3% lang of the overall individuals involved sa anti-drug operations. At kung sabihin ng pre-trial chamber na legitimate government operation yon, kahit na po may namatay na 3% ay hindi po yun malilink na si FPRRD gumawa ng crimes against humanity kasi alam naman po natin in government operations, specifically sa police and sa military, ay meron po talagang casualties involved. So yan po yung kailangan talaga dito ma-establish ng defense whether or not this is a legitimate government policy and whether or not reasonable ba yung number of individuals na matay in relation to that government policy. Tapos yung sa prosecution side naman po, ipapakita nila dapat ay meron talagang inutos or ginawa sa FPRRD na policy na specifically targeting itong 3% lang na individuals. Yan po yung mga nakikita kong mga legal position na magbabanggaan dito. Okay, so anyway po, tuloy tayo.
So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory with respect to the definition of the targeted population is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting two alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, including the very same people who put him into power. Such a suggestion is not just incomprehensible, it is quite bizarre. The reason for this rather strange assertion, so I submit, is grounded in the prosecution's latest brainstorm on the matter, which it set out last year in a brief, appealing a decision of its very same pre-trial chamber in the El Hishri case. And I do apologize in advance for the rather dull expose which will follow, but I do find it instructive to illustrate the chameleon-like nature of the prosecution's case theory. In this instance, Your Honours found that the civilian population attacked by El Hishri comprised prison detainees professing a certain political ideology. In so doing, Your Honours declined to issue an arrest warrant for El-Hishri, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El-Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. The pretrial chamber, this same pretrial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that it is prosecuting before this court. The resulting logic of Your Honour's decision in El-Hishri to the prosecution's case theory in a Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the El-Hishri decision, the gurus on the top floor of the office of the prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pretrial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, a segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society, and thus rendering them susceptible to an attack. How does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you? It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group, such that they can be deemed a civilian population for the purpose of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorizing an investigation in the Kenya situation, where at paragraph 81, the pretrial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole, and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly, even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards.
Oh, wow. Attorney Kaufman.
Madam President, Your Honors, I conclude.
Atin yung opening statement ng defense or ni Attorney Kaufman, yung abogado po ni FPRRD. So ito pong papanoorin natin is from the actual ICC, International Criminal Court YouTube channel po. So yan po, makita nyo naman dito sa lower left. INTL Criminal Court, 190,000 subscribers. Okay, so ngayon panoorin po natin.
Now over to the defence. Mr. Kaufman, please.
Thank you, Madam President. Thank you, Your Honours. And I thank Mr. Tuyan for his intervention. But I feel that I ought to remind him that this is a court of law which decides matters on the basis of evidence, not on the basis of political demagoguery, and not on the basis of desire to effect regime change despite the democratic will.
Okay, wait lang. Comment lang guys kasi sinabi ni Attorney Kaufman, demagoguery. So yung demagoguery po, yung easiest way na masabi ko dyan is ano po, na hindi pwede yung basta-basta or pang bardagulan ng mga statements basically dito sa ICC. So maganda lang pakinggan kasi demagoguery. Okay? So anyway po, tuloy tayo.
And certainly not on the basis of statements made by Ombudsman Jesus Crispin Remula, who professed that domestic justice would be denied, according to Mr. Butuyan, because of the lack of forensic reports and police reports. Now, I don't know which case Mr. Butuyan metaphorical ship sailed into, but he clearly hasn't read the evidence. Whilst he was speaking, we examined the evidence, and out of that evidence, we found at least 35 reports substantiating 49 of the incidents which are mentioned in the document containing the charges. Your Honours, Rodrigo Duterte was and will always remain a unique phenomenon. His style of statesmanship was novel and unpalatable to many. His expletives and hyperbole grated, while his honesty and wild popularity irritated. He spoke openly, from the heart, sincerely and truthfully. And what a contrast between him and his successor in the Malacanang.
Okay, so quick comment lang guys. So I personally agree po dun sa statements ni Attorney Kaufman regarding sa personality ni FPRRD. Alam naman po natin na very unique po talaga si FPRRD compared to past presidencies kasi siya lang po yung number one, very loud, very vocal, at talagang pinapakita yung gusto niyang gawin via actions. Diba? Kung naalala pa nga ninyo, dati sa Davao, meron siyang pinakain na, if I'm not mistaken, papel po ata yun eh. Diba? Doon sa isang abusadong, I'm not sure kung resident or bisita lang yun eh, sa Davao City. Pero you can search that po, may pinakain si FPRRD. So, hindi ko na i-discuss kung meron ba mga legal implications yung ganong actions. But my point here is, kakaiba po talaga at unique sa FPRRD. Yun nga po, he's very loud, he's very vocal. And, ano po, kung ako lang tatanungin, makikita nyo talaga na meron siyang spirit of public service. Okay, so yan lang po ang masasabi ko ngayon. Tuloy po ulit tayo.
For President Rudy, his word was his word, and the people knew it. For President Bong Bong, his word is for the wind, and the people will not forget it. Let me remind everyone of the letter which President Ferdinand Marcos Jr. signed, it's on the screen, and in which he gave a cast-iron undertaking that his government, and I quote, will not assist the ICC in any way, shape, or form. Well, as we know, he failed to keep that promise. Rodrigo Duterte was unconstitutionally hijacked and unceremoniously hauled off to The Hague. And when called upon to defend his master's actions and the said letter at a Senate committee hearing, The then Secretary for Justice, once again Mr. Jesus Crispin Remula, persisted with the same dishonest theme. And I quote his words, "We did not assist the ICC. We continue with the very tone of the letter that we did not assist the ICC and we did not have any contact with them." So he said, but with a document emanating from the prosecution team opposite and disclosed to us a mere week ago, not as information material to the preparation of our defense, but as exonerating evidence, we can now substantiate what we have suspected for a long time. The document comprises a transcript of a telephone call covertly recorded between four parties who cannot be mentioned in public, and one of these parties was boasting about how he was acting as the silent partner of President BBM, managing a scheme to funnel witnesses to this court while all the time ensuring that he could guarantee President BBM's plausible deniability.
Okay.
So it is indeed.
Wait lang guys, comment tayo kasi that's actually a very big revelation from Attorney Kaufman dito. Sa inexplain po ni Attorney Kaufman, di ba, yung earlier statements po ng PBBM admin, ayun nga, hindi daw sila magko-cooperate sa ICC. Pero eventually nakakuha sila ng copy ng ICC warrant. So, yung point dito ni Attorney Kaufman na contradicting yun, hindi yun nangyari talaga yung hindi nga mag-cooperate kasi eventually nakakuha sila ng ICC warrant, napadala si FPRRD sa The Hague, and then meron din daw silang recording na nakuha na sinubmit mismo from the prosecution daw na may 4 na individuals tapos yung isa nagmamayabang pa na makakaano daw siya, makakapadala siya ng mga witnesses sa ICC. Tapos with the actions sa gagawin daw nila ay magkakaroon ng chance si PBBM to deny any involvement. So yan po yung medyo malaking pasabog dito. Although hindi po binanggit dito ni Attorney Kaufman kung sino yung 4 na yon na recorded phone conversation based on Attorney Kaufman's statements. So kung lumabas yun in actual public, doon ngayon mukhang mahirapan na magkaroon ng deniability talaga si PBBM in relation to the ICC case ni FPRRD. Kasi based on that conversation nga daw po, ginagawa talaga nila or sineset up nila in a manner na magkakaroon ng plausible deniability si PBBM as to the happenings in relation to the ICC case ni FPRRD. So that's a very big a very big revelation kasi galing mismo yun sa prosecution, sa evidence po ng prosecution. Okay, ngayon tuloy tayo.
Indeed, the defense case that President Ferdinand Marcos Jr. set out to neutralize Rodrigo Duterte and his legacy. Yes, Mr. Deputy Prosecutor, I used that legendary word, neutralize. So central and so essential to your case theory, because you know just as well as me that I'm using the term metaphorically. And now I turn to the substance of the charges, but before I do, a word or two about the geopolitical context.
Okay, so wait lang muna, comment lang muna tayo. So itong opening statement actually ni Attorney Kaufman, kung papakinggan talaga natin siya, it's more on a political statement talaga kasi tinatry niya ipakita na may political persecution against FPRRD na ginagawa yung current president or yung administration daw po ni PBBM, allegedly, according to Attorney Kaufman. So yung masasabi ko lang po dyan, hindi yan siya directly na nire-refute ni Attorney Kaufman na hindi nag-commit ng crimes against humanity si FPRRD. This is what we call a supporting statement po kung saan na gusto ipakita nga ni Attorney Kaufman may political persecution against FPRRD. Therefore, posible pong may issues yung credibility or genuineness nung evidence ng prosecution. Okay? I-clarify ko lang din, hindi naman sinabi ni Attorney Kaufman na yun yung main purpose niya. Pero of course, as a practicing lawyer, when you make supporting statements, it is usually to indirectly attack the legal theory of the prosecution. So like what I stated, since political speech po to, kung ako po tatanungin, para siyang political speech na hindi naman directly refuting the crime against humanity, but he is trying to establish na may political persecution. So yun nga po, sumusuporta lang yun sa overall theory nila na posibleng yung mga evidence, ganyan, witnesses ay may issue on genuineness or credibility. Ina-explain ko lang po tong side na to kasi baka po kayo rin mismo nag-react na yung sinabi naman ni Attorney Kaufman ay wala namang kinalaman sa crimes against humanity. It's more on yung political side lang. So most likely, yan yung isang reason kaya may ganitong political statement si Attorney Kaufman regardless of it not directly refuting the allegations. Okay, so ngayon tuloy po tayo.
The scourge of illegal narcotics is not unique to the Philippines. As we all know, it afflicts Latin America, where I can name 3 countries where the death rate at the hands of vigilantes and law enforcement agents per capita population is higher than it ever was under Duterte. And as you should know, and you will hear from the prosecution, at any rate, the Philippines as a country is uniquely positioned to act as a transit hub for the trafficking of narcotics emanating from the cartels in China. And with or without Duterte, so we argue, the death rate would have kept on rising. Indeed, as we will prove with statistics and reports, the death rate flowing from narcotics-related crime actually increased after Rodrigo Duterte left power. And where, I ask you, has the International Criminal Court been since? Now, a colleague of the victim's representative sitting opposite, a certain self-styled legal assistant to ICC counsel, rose up and famously stated in one of her many voluble interviews to the media that Rodrigo Duterte conducted not a war on drugs, but a war on the poor. A war on the poor, I ask you? If anything, the totally lawful Duterte campaign against illegal drugs and their suppliers took place when his administration was actively promoting some of the most important redistributive policies in years, all with the aim of alleviating poverty. Legislative reform in 2017 to reduce personal income taxes for workers, social protection expansion known as the 4Ps designed to provide regular cash transfers to needy and multi-child families, universal health care, and need I say more, the Magna Carta of the poor, setting out the right to adequate food, decent shelter, education, and a highest standard of health. The fact that the majority of those who died as a result of drug-related crime were living in the most deprived areas is something which is endemic to every afflicted society. But can anyone seriously accuse this man, Rodrigo Duterte, who has lived such an openly frugal existence, of taking up arms against the needy? This is the man who at the age of 5 arrived in Davao to live in a modest shack where rain leaked through the roof, forcing him to crawl under the kitchen table to take shelter. This is not the man born with a silver spoon in his mouth and groomed to the presidency from childhood. This is the man who was born to a lawyer and a governor who taught him discipline, values, and respect for the people by being one of the people. This is the man who, as president himself, shined like others before him, and even those after him. He's not in the palatial grandeur of the Malacanang, but in Spartan quarters of his bodyguard's hut. His diet consisted not of prime cuts of imported Australian beef, but of dried fish and boiled rice. A man of simple indulgences, his pleasures were to be found not on the cocktail party circuit of Forbes Park, but on coastal roads where he roamed and cruised on his motorcycle, not looking for people to kill Mr. Prosecutor, but almost killing himself because of his love for speed. This is the man who paid and paved his way through law school, passing his bar exam in 1972, more or less on the same day as Marcos Sr.'s tanks were grinding and rolling their way through the streets after the declaration of martial law. And it was on that significant day that Rodrigo Duterte was exposed to the tyranny of oppression and the abuse of power by the elite, and he took a decision. On that day, he chose to devote himself to a life of selfless public service. As a professor at the local police academy and as a public prosecutor in Davao, Rodrigo Duterte developed a lifelong passion, some would say an enduring obsession, for law and order, something for which he unapologetically enforced throughout his time as mayor of Davao City. Not, as the prosecution say, through sowing murder and mayhem, but through winning the love, respect, and admiration of his fellow citizens. The very same citizens who continued to re-elect him time after time, term after term, on no less than 7 occasions over more than 2 decades. And throughout his 20 or so years tenure as the mayor of Davao, Rodrigo Duterte and his family transformed that city from an outpost of communist insurgency and criminal violence into what is now one of the safest cities, not just in the Philippines, but in the entire world. This was indeed the so-called Davao model, which the prosecution wants to persuade you was code for unbridled criminal violence. And this was the type of leader that the Filipino nation wanted in 2016. So, Rodrigo Duterte was elected into power, not in spite of, but specifically because of his firm and uncompromising commitment to upholding law and order. And after his election as president, Rodrigo Duterte remained a man of the people, without seeking to patronize the people. Gung-ho in his ways and with a belligerent tone, he spoke the tough tongue of the street, not the dissembling discourse of international diplomacy. He said what the people wanted to hear, but he said it in a way that offended sensibilities of world leaders unaccustomed to hearing it, one in particular, and that was what set him on the slippery slope to a prison cell in The Hague. And let me tell you how it works. It starts with the media. controlled by the powerful and the politically influential. With a sensational headline and a twisted editorial slant, the moguls sell their papers while promoting the partisan agenda of their backers in power. They highlight the salacious content while ignoring the true context, because that is what captivates the reader. And so it was with Rodrigo Duterte, whose speeches were fertile fodder for his enemies and detractors. A man whose hyperbole, bluster and rhetoric, once published, became a natural target for privately funded NGOs and human rights activists, a loose collective more commonly known as civil society. These people descended upon the Philippines to advance an agenda even more lacking in objectivity than that of the media. And heavily funded by tycoons with even grander designs, they print their glossy reports, replete with iconic photographic images of grieving families and dead bodies in rain-swept, nighttime crime scenes, all dramatically illuminated with the fluorescent glow of neon. Images carefully crafted to shock the conscience and to sway the emotions, and, I may say, to be used by the prosecutor when they don't even relate to the charges. And they gave their slick reports bold titles, lifted straight out of a James Bond movie, such as License to Kill, One Shot to the Head, You Can Die Anytime, or simply, They Just Kill. The photographers are fated and their shots exhibited as art all over the world, and the brave journalists who act as their sources win awards and Nobel Prizes. And slowly but surely, their narrative becomes the sacred, unchallengeable, and unshakable truth. And so the pressure builds up, and the academics who haunt the corridors of the progressive left law faculties far away in the United States tweet their research and publish their articles pontificating about crimes against humanity, systematic attacks against the civilian population, and they point their finger at one man alone, and bandy about slogans such as accountability and the prevention of impunity. They give their gratuitous advice on what should be done, sometimes academics who formerly worked alongside the prosecutor of the International Criminal Court. Communications and complaints are filed, and the rest, as they say, is history. In any event, we're not gathered here today to judge a man on the basis of his coarse attitude or his vulgar language.
Okay, wait lang guys. Comment tayo muna. So yung inlay po natin na part ng statement ni Atty. Kaufman, yung mahaba po. Nagbigay siya ng personal history na FPRRD, personal circumstances niya growing up, simula nung bata pa siya, nag-law school siya, kung bakit daw, at kung paano rin daw po siya nagkaroon ng passion for law and order during the tyranny daw po of the martial law. So, ang masasabi ko lang po doon, that is more of a supporting statement lang of the defense, not necessarily a defense na directly nire-refute or kinocontradict na hindi siya nag-commit. Kasi yung gusto lang i-establish dito ni Atty. Kaufman, kung ako po yung tatanungin nyo yung dating po sa akin, yung gusto i-establish ni Atty. Kaufman dito is because of the way si FPRRD was brought up, was raised, the way he developed as a person basically, ay hindi daw niya magagawa yung war against the poor na sinasabi ng isang lawyer dun sa prosecution, kasi he was actually raised in a manner na maintindihan daw ni FPRRD yung situation ng poor. Therefore, it would be highly impossible daw na magko-conduct siya ng war on the poor. But hindi yun pa directly talaga kino-contradict, kasi I'm sure dito may evidence yung prosecution eventually niyan ipapakita kung how yung pagpapaya was committed eh. So yun yung kailangan nila magpakita rin ng actual evidence na magko-contradict na hindi nangyari yung nag-order si FPRRD na ipapaya si ganito, na papayahin nyo yung mga ganyang tao, ganyan. So pag may ganun po silang defense, yun ay direct evidence talaga na directly refuting or contradicting po yung mga ganong allegations. Pero of course, if you want to further strengthen that defense, you also have to show kasi the mindset of the individual or the personality of the individual. Kasi importante din yung criminal intent, diba, in criminal cases. So, yan pa lang po ang masasabi ko dito, kasi wala pa silang actual direct evidence na pinapakita na magre-refute directly eh. More on mga supporting pa lang of the circumstances. Okay, so anyway po, tuloy tayo.
This court has convened a confirmation hearing to verify whether substantial grounds exist to believe that Rodrigo Duterte, the people's president, together with various so-called co-perpetrators, over the years of his governance, devised a criminal policy of wholesale and wanton murder. And since we are in a court of law, it is worth stressing, although I should not have to, cases are decided on the basis of evidence, not supposition, not rumour, not spicy gossip, and certainly not on the basis of political rhetoric and bluster. Because at the end of the day, were it not for those belligerent and controversial speeches, there would have been no impetus to bring the People's President to The Hague. And when the prosecution's evidence is examined, I would ask you to keep an open mind and to question not just whether that evidence has been selectively presented, but whether there exists evidence which the prosecution has failed to produce. And I say this with justifiable cause, particularly with respect to the Duterte rhetoric. As we will prove during the substantive part of our submissions, the notorious speeches on which the prosecution relies have been cherry-picked to suit its narrative while ignoring the many other speeches when the former president tempered his bombastic language by clear reference to the principle of lawful self-defense. We, the defense, have read as many of these speeches as we can find. In fact, in our poky little office on the top floor of the furthest building away in this complex, we have a counter which ticks and ticks. And whenever we come across a speech which contradicts the prosecution's murder theory by reference to self-defense, we give a cheer. And the counter goes up once more, and we celebrate one more nail in the coffin of the prosecution's case theory. As the statistics stand as of today, in contrast to the 20 speeches on which the prosecution relies to prove incitement to kill, we have found 35 more which say the complete opposite. Let me give you two examples from the very speeches that the deputy prosecutor himself cited today.
Okay, interesting.
To the famous Pietà speech, which the deputy prosecutor referred to. So, this is what the deputy prosecutor said. Those of you who are still sober, those who haven't tried illegal drugs, if you don't want to die or get hurt, don't rely on the priests, including human rights advocates. They won't be able to prevent deaths, and so it goes on. But if we look further on, in the very same speech, something which maybe the deputy prosecutor didn't do, this is what he had to say. To our police officers and other officials, do your job, and you will have the unwavering support of the office of the president. I will be with you all the way. Abuse your authority, and there will be hell to pay, for you will have become worse than criminality itself. Well, there you are. You have it straight in your face. Pexo, exonerating evidence within.
Okay, comment lang guys. So just a quick break lang po. Gusto ko lang po magpasalamat sa inyong lahat, my fellow taong bayan, mga kasimor ko, because we have recently crossed the 380,000 subscriber mark po. So thank you very much po sa lahat ng nag-subscribe, and of course thank you in advance po sa mga magsasubscribe pa lang. And tandaan po ninyo, pag sa YouTube po kayo mag-subscribe, 100% free po yan. So hopefully po you can consider subscribing, and of course i-like din po mismo yung video na to. Okay, so ngayon po tuloy tayo sa discussion. Yun, maganda na yun kasi it's directly contradicting yung present ng prosecutor kanina, although hindi ko na flash na dito eh. So at least maganda po yun kasi napakita doon na ang sinabi ng FPRD, pag gawin nila yung trabaho nila, supported sila ng presidente. Pero kung mag-aabuso din po sila ng kapangyarihan nila, hindi na sila supported kasi magiging criminal na rin or mas masahol pa daw sila sa criminal. Yung sabi ni FPRD in the very same speech na ginamit nung prosecutor. So this is actually a strategy or one way para ma-discredit yung statement na ginamit ng prosecution kasi kung makita nyo yung latter part very kakaiba naman, diba, or contradictory to dun sa initial na sinabi. So yan yung isang reminder ko sa inyo, my fellow taong bayan, na ibang-iba po talaga pag political speeches yung pinapakinggan natin from actual speeches or from legal speeches kasi pag political, madami po talaga yung mga exaggerations, hyperbole. Ganyan po kasi talaga yung politiko, di ba? Pag political speech, he will make statements na gustong marinig ng tao para makakuha ng support. Diba? Ganyan po. Kaya nga lagi ko pong sinasabi sa inyo na maging mindful talaga tayo pag political speeches. Tapos yung kailangan natin talaga tingnan dyan is aside from the actual na sinabi, yung integrity at personality nung naggawa ng statement na yon. Kasi again, pag political speech, talagang ma-hype up po yung tao niyan. Yan yung purpose naman talaga niyan, to gain support dun sa politiko himself or to the policies na pinupush po ng politiko na yan. Ito, maganda na po to, itong part na to na ginawa ni Atty. Kaufman para at least hindi self-serving ba? Kasi yung prior statements kasi niya, of course, being the defense, he will make statements na talagang favorable sa legal defense theory nila. Diba? Pero dito, directly refute na niya. Okay, so anyway po, tuloy tayo.
Claim to be the prosecution incriminating evidence. I won't take up my time by showing you the second speech, but there is one. If I have time at the end, I will show it to you. So if you add to that another 10 speeches out of the 20 speeches on which the prosecution rely in its document containing the charges. After all, we are in a court of law, and we rely on evidence. And what is the evidence that's produced of these speeches? 20 of them. 10 of them, I submit, and we will show this in the substantive part of our submissions, contain exonerating evidence which support the defence case theory. In other words, if you add the 10, which we've identified in the prosecution's 20, to our total of 35, we come to 45 speeches versus 10, which we say support the use of force only in self-defense. That is 350% more speeches in favor of our defense and 354% more reasons not to confirm the charges. And you can bet your bottom dollar that at the end of today's proceedings, either the victim's self-styled legal assistant to ICC counsel or a prosecution intern will be tasked with scouring the web, looking for the means to prove Kaufman wrong. And I will declare it, and I'll declare it loudly and clearly, as if the prosecution didn't know it already. It's not enough to state that since the former president made those extremely inflammatory statements and deaths occurred, that he must, as a matter of course, be criminally responsible for those fatalities. At this stage of the proceedings, the prosecution needs to show substantial grounds to believe that the former president actually desired and foresaw that people would be killed as a result of his incendiary language. The prosecution to assert that Rodrigo...
Wait lang guys, comment tayo. Maganda yung part na yun dun. So dun po papasok yung tinatawag na guilt is personal, di ba? Kasi in criminal cases, the general rule, kung sino yung author, siya po yung guilty dun. Unless mapakita po na may conspiracy or may principal na nag-induce or nag-utos na gawin yung mga ganong crime. Diba? So dito kasi yung pinaka-defense talaga ng defense, although hindi pa nila sinasabi, but based on all my research regarding sa defense po nila Atty. Kaufman, is mga lawful executive orders yung binigay ni FPRRD to fight the war against drugs or to perform the war on drugs. Hindi naman po siya directly daw nagsabi na ipapaya mo lang si ganyan for the sake of ipapaya. Kung hindi, i-implement mo yung policies which will fight the illegal drug trade dito sa bansa po natin. Tapos as a result of that drug trade, nagkaroon ng casualties. So from there kasi, kung yun yung mapakita talaga nila Atty. Kaufman, magandang defense po talaga yun because that is a legitimate government policy naman po kung gusto nila mag-war on drugs. And kung tingnan nyo po nga mismo ngayon sa Amerika, pati si President Trump, diba, meron na din daw siyang war on drugs na ginagawa din. So yan po yung maganda na mapakita dito nila Atty. Kaufman. Tapos yung sa side naman po ng prosecution, kung may mapakita sila na sinabi mismo ni FPRRD na ipapaya mo yung si ganyan, si ganyan, si ganyan, pag ganun po, iba na po talaga yun kasi that is a direct order already kung saan pwede pumasok as principal by inducement. Pero kung puro indirect connections lang, correlations na because of this speech, kaya daw ginawang ganyan, medyo maano po yun, medyo shaky po yung ganong position ng prosecution kung ako tatanungin ninyo because it is indirect pa yung mga link na ginagawa nila. And alam naman po natin in criminal cases, sobrang taas po yung evidentiary requirement, diba? Reasonable doubt po. So pag mga questionable or yung pag-reaction po natin, pag tingnan natin yung evidence na parang malayo pa or wala talagang direct link, pag ganyan, ma-acquit po yung akusado. Okay? So hindi ko po sinasabing ma-acquit na talaga si FPRRD. Na-explain ko lang po yung mga legal position. So kala Atty. Kaufman, their legal position is it was a legitimate government policy, yung war on drugs. And of course, yung sa prosecution naman po is hindi yun siya legitimate na government policy, kundi it's a direct policy kung saan ipapapaya lang yung mga certain individuals. Yan po yung mga legal theories in a very simple way to explain it na nagbabanggaan. Okay, so anyway po, tuloy tayo.
Duterte hoped for deaths to occur or was recklessly indifferent as to whether deaths would occur, which he was not. That's insufficient. So once more for the record, Rodrigo Duterte's language was aimed not at suspected drug pushers as the prosecution would have it, but directly at those poisoning society with their substances, and not, I stress, with lethal intent. His rhetoric was calculated to arouse fear and obedience, to instill fear in their hearts, and to inculcate a respect for the law in their minds. Nothing more, nothing less. That was his intent, and it was not criminal. And as many of these drug pushers demanded to enter prison, I remember seeing the images on the television, lining up to surrender and to enter prison. Now, I challenge my colleagues opposite to prove otherwise, because as we all know, in a criminal process, the burden of proof is on the prosecution. They brought this case, and they need to prove it. Rodrigo Duterte need not convince the world of anything, and that is to his fortunate advantage given his current medical condition. he stands behind his legacy resolutely, and he maintains his innocence absolutely. Now, I turn to the general fairness and objectivity of the investigation, which, as we all know, is meant to be an impartial evidence-gathering exercise. As an ex-prosecutor myself, I'm used to investigating agencies pursuing all reasonable lines of inquiry, assimilating all testimonies, and digesting all documentation and forensic evidence, recommending who to target for prosecution, but not so with this prosecution. When we, the defense, study the course of the investigation in this case, one thing is plain as a pikestaff. The chief prosecutor of this court, Mr. Karim Khan, not only failed miserably to carry out his duties under their own statute, requiring him to examine exonerating circumstances as well as incriminating, but he single-handedly contaminated it, so we alleged, by pursuing a one-track crusade with a view to a predetermined objective. Let me explain. Although the ICC officially authorized an investigation into the so-called Philippines situation in late 2021, it was deferred a few months later back to the Philippines for the official investigation to resume only in late 2023. But the real meat of the investigation into Count 1, relating to the activities of that fictitious construct, the Davao Death Squad, had effectively started way before then, with the sole objective of nailing Rodrigo Duterte. Indeed, all the way back in 2018, during its so-called preliminary examination, the prosecution had an individual who will be referred to as P1, handed to them on a silver platter. This P1 had been interviewed at an earlier date by none other than Chief Prosecutor Karim Khan, in his former capacity as a private lawyer, and a self-professed
Ay, naputol. Wait guys, wait. Okay, so comment na lang muna tayo guys bago natin i-continue. So itong part ng statement ni Attorney Kaufman, he is trying to establish, kung ako po tatanungin ninyo, there is an appearance na he's trying to establish na may conflict of interest yung prosecution ng ICC sa case ni FPRRD kasi yung chief prosecutor daw may in-interview na prior na allegedly may involvement kay FPRRD dun sa war on drugs or basically dun sa international humanitarian law na case sa kanya na binibuild pero private lawyer pa lang nun si Chief Prosecutor Khan. Diba? So magkaroon ng interview during his private practice days till eventually naging prosecutor siya ng ICC tapos tinuloy nila yung ICC case against FPRRD. So from that circumstances po, kung ako tatanungin ninyo, mukhang gusto ipakita ni Attorney Kaufman na may conflict of interest nga. Okay, so anyway po, tuloy tayo.
preparation. And what was this information with which Karim Khan had helpfully provided her? A book on which the prosecution relies as evidence. A trashy, scurrilous item of pulp fiction entitled Duterte Harry. Your Honours, the picture on the front cover of that book says it all. It really does scream objectivity, doesn't it? I say that sarcastically, of course. Fortunately for us,
Wait nga lang. Kung pansin niya si Attorney Kaufman, lagi na niyang kinaklarify, may clarificatory follow-up sentence siya. Like dito, sabi niya, it screams of objectivity. Tapos, but I say that sarcastically. So, kinaklarify niya siguro kasi baka ma-misinterpret siya like yung sa mga previous kasi niyang pleadings, di ba, na parang tinitake seriously kung walang actual clarification na pinoprovide si Attorney Kaufman kahit na joke or it appears na joke yung kino-quote niya dun sa mga past pleadings niya. So sinishare ko lang to kasi na-observe ko lang kasi nabasa ko rin po yung mga previous pleadings ni Attorney Kaufman eh. Ngayon meron na siyang laging pahabol kung whether or not sarcastic ba o hindi yung statement niya. So tuloy po tayo.
has now disqualified Chief Prosecutor Karim Khan from this case. A welcome development as a matter of ethical propriety, but in our opinion, too late in the day to salvage the integrity of the investigation that he had supervised. An investigation in the course of which he concealed his former role as the victim's counsel, who had deemed our client a suspected murderer as far back as 2018 and right up to the very day before this pre-trial chamber issued its arrest warrant.
Okay. Quick explanation lang. So kung makita nyo na tanggal na si Chief Prosecutor Khan from the case because of ethical reasons daw. So ngayon yung gusto i-point out ni Attorney Kaufman na since si Chief Prosecutor Khan yung nag-investigate, therefore questionable yung overall investigation or examination na nangyari sa case ni FPRRD. Yun yung gusto niya i-establish dito.
Your Honours, over the next few days, we hope to convince you of the wholly insufficient nature of the evidence against Rodrigo Duterte. We will show you that the paltry number of speeches on which the prosecution rely do not manifest criminal intent. We will also convince you that as hard as they tried, the prosecution's investigators couldn't get even one of its criminal cooperating witnesses, whose reliability is next to zero, to admit that they heard the former president, Rodrigo Duterte, give an order to kill at any time relevant to the charges, or with respect to any of the incidents. And we hope that when you conclude your deliberations, Your Honours, that you will dismiss these grievously misplaced and politically motivated charges. We will ask you to send Rodrigo Duterte back to his family, and we will ask you to give back to the Filipino people their tatay digong. Thank you, Your Honours.
Okay.
The presiding judge.
Okay, so in summary guys, itong opening statement ni Attorney Kaufman, ko ako po ang tatanungin ninyo, medyo tinouch on na nila yung legal defense theory nila, which is number one, puro indirect evidence yung meron yung prosecution, kasi dito sa last part ng statement niya, yung witnesses daw mismo ng prosecution, wala or hindi nila masabi na may direct order si FPRRD na ipapaya yung mga ganitong tao. So yun, puro indirect mga evidence yung meron sila. And then number two, yung nirely nila ay questionable because puro mga political speeches ni FPRRD, which is may certain portions in doon kino-contradict yung actual na kinote lang nila from the same speech. Diba? So again, this is a reminder na yun nga po, maging mindful talaga tayo pag political speeches. And then pangatlo po, yung sa angle sa Chief Prosecutor kay Chief Prosecutor Can, kung saan meron siyang questionable or conflict of interest issues which actually resulted to him being expelled from the case. Therefore, since si Prosecutor Can yung nag-investigate, questionable daw yung actual investigation. So yun yung nakikita kong defense theory dito nila Attorney Kaufman. So overall, ang masasabi ko lang, kung yun lang talaga yung evidence ng prosecution na puro indirect evidence and then puro based on political speeches, mukhang maayos naman yung defense dito na mangyayari kila FPRRD. Kasi like what Attorney Kaufman stated, it is fundamental in criminal law na he who alleges has the burden to establish his case, di ba? Yung prosecution po, yung kailangan talaga magpakita na lahat ng essential elements of the crime that is being alleged against the accused ay ma-establish nila. Tapos kung ma-establish po nila yon, dapat it must be established beyond reasonable doubt. Meaning na pag ikaw po ay isang reasonableng tao, pag tingnan mo yung facts of the case, tingnan mo yung evidence of the case, yung magiging conclusion mo ay mukhang siya talaga yung gumawa at wala nang iba nung krimen na ina-allege. Diba? Hindi ka po magdududa talaga. Okay, so yan po ang mga legal principles and legal theories na nag-a-apply dito sa case ni FPRRD. Okay, so hopefully klaro po yan. If you like more legal videos and current events, subscribe lang po kayo sa channel ko. And until next time, see you all. Bye-bye!
Alright, bye-bye.